Very good morning, good afternoon to everyone. You are welcome to the NITYA monologue on Tale of Transitional Credits. Has the Supreme Court put a permanent quietus to the issue? So, as we all know, that earlier the regime was of central excise, service tax, and VAT. Effective July 1st, 2017, GST was enacted and a new regime came. Then the first issue was transition from the erstwhile regime to the new regime. And this happened through some transitional provisions which were introduced in the GST law. So chapter 20, which is from section 139 to 142 of the GST Act, that provided for the provisions relating to transitional provisions. And the relevant rules were from rule 117 to 121 of the CGST rules. Now, the first issue that came up was the technical glitches. So almost all taxpayers face technical glitches while filing Form Tran 1 or Tran 2, and they could not file the forms in the portal. Also, what happened was that the rules only prescribe that the transition can be taken place of those credits which were as per either the returns filed for the period ending June 2017 or as were allowed in terms of section 140 of the CGST Act. And therefore, multiple issues came up and the taxpayers found it difficult to transition. The forms were new. There were errors committed on the part of taxpayers also in reporting in the wrong columns. And these resulted in blocking of credits that erstwhile vested right or the accrued right of SENVAT credit or VAT input tax credit could not be transitioned to GST. Resultantly, a lot of litigation happened. Multiple writs were filed before various high courts, and most of them were decided in favor of the taxpayers. So if we see the journey, I'll give you the historical background also. So if we see the journey, it started, GST was introduced in July 2017. So initially, what section 140 or rule 117 prescribed was 90 days timeline. Now, for filing of the Form Tran 1. Thereafter, this timeline was extended in November 17, and lastly, it was December 27, 2017. To overcome the technical glitches, White Circular dated 3rd of April 2018, GST Council constituted Information Technology Grievance Redressal Cell in the GST network to look into the aspect of technical glitches. This happened in April 18. Thereafter, in September 18, Rule 117.1a was introduced. Now, this 117.1a essentially was to cater to the technical glitches on the portal. So what it did, it allowed the commissioner to extend time limit where ITGRC certified that yes, so and so taxpayer experienced technical glitches, and in such cases, the commissioner would extend time limit. Also, then multiple rulings started coming in. There were Gujarat High Court decisions, Siddharth Enterprises, and some other decisions. There was Punjab Haryana High Court decision in November 19 of Adford Technologies. These were favorable rulings, which clearly stipulated that the erstwhile taxes were accrued right, and the same should be allowed to be transitioned, and technical glitches on the portal or any error on the part of taxpayer cannot come to the hindrance. They have the credits have to be allowed and transitioned to the GST regime. And essentially the challenge was vis-a-vis Article 14, that there was no procedure prescribed, and the procedure that was prescribed was not as per law, or unequal treatment like Rule 117.1, which prescribed for normal period of 90 days, whereas if the glitch is on the portal, then that case was covered by 117.1a, where the time limit was extended up to 31st of March 2020. So why different treatment is being given? Then Article 19(1)(g) was invoked. That was with respect to the right to trade, etc., which was getting hindered. Article 265, that by not allowing transition of such credits, in a way, government was recovering tax without any authority of law, because the erstwhile credits which were accrued in favor of the taxpayer ought to have been allowed to be transitioned. And again, Article 300A, which was right to property, that a property of the taxpayer was being taken away without following due process of law. So all these articles were invoked, and high courts came to the rescue, as I mentioned, in Siddharth Enterprises, Gujarat High Court, Adford Technology, Punjab Haryana High Court. This matter, in fact, Adford Technologies SLP was filed by Union of India before Supreme Court, and Supreme Court rejected, dismissed the SLP. That means this Adford Technology became final. Also, there were multiple other rulings, negative rulings also. There was one from Bombay High Court, NELCO, where they held that the Senvet credit or the input tax credit is only a concession, and taxpayer is required to strictly follow the rules prescribed under the GST law. And if that has not been adhered to, then the credit lapses. So such negative rulings were also there. Then came famous brand equity judgment of the Delhi High Court, where Delhi High Court considered all the judgments, including NELCO, including there was one Willowwood from Gujarat High Court itself, which was also a negative ruling. So after considering all the judgments, brand equity clearly laid down that the limitation, normal limitation as prescribed under the Limitation Act should apply, and that taxpayers' rights cannot be taken away in this manner. And if there are technical glitches, that is for the department or the revenue to look into. The GST Council and the GST network should look into it, and taxpayer cannot be made to suffer for such lapses. So they allowed time limit till June 2020. Thereafter, after brand equity, in May 2020, the government came up with the retrospective amendment in Section 140. This was for the reason that in brand equity, one aspect which was dealt in was that the time limit was not prescribed under the law, under Section 140. There was no time limit prescribed, but this 90-day timeline is coming only from Rule 117(1). So the court held that this is a delegated legislation and it is only a directory time limit. It is not a mandatory time limit. There is no provision under Section 140 to prescribe such time limit. So government came up with this retrospective amendment whereby they allowed prescription of time limit also through rules. So that was the amendment, and this was a retrospective amendment from July 1st, 2017 itself. Thereafter came SKH judgment of Delhi High Court in June 2020. Now this, I had the privilege of arguing this matter before the Delhi High Court. And in this judgment, even the retrospective amendment was considered, and yet the Delhi High Court maintained its stand that even after the retrospective amendment, the time limit prescribed under Rule 117(1) is directory, and that taxpayers' right cannot be withdrawn like this. And lastly, what we have, which is the subject matter for our today's session, is the Supreme Court recent ruling in July 22, whereby the Supreme Court has given directions to the government, to GSTN, to GST Council to reopen the portal for the period. I'll just come to this when we discuss the Supreme Court order in detail. So what Supreme Court has said, it has directed GSTN to open the portal for filing of Tran 1 or Tran 2, or revising already filed Tran 1, Tran 2 in case there are any issues or any errors that were left out. And the portal will remain open from September 1, 2022 to October 31st, 2022. So for 2 months, this portal will remain open. I know there are multiple questions that we have received, and some of the questions would get answered during my session, So just hear me out, and you, in the end, we will discuss the questions also. So one first point is that this 2 months, the portal will remain open both for fresh filing or for revising the already filed Tran 1, Tran 2. Second, that the direction that the Supreme Court has given is that all taxpayers can file or revise their Tran 1 and Tran 2, irrespective of whether they filed any writ petition earlier, whether their cases were considered by ITGRC as valid, involving technical glitches or not. So even those cases will be covered. So any person can file fresh Tran 1 or can revise its already filed Tran 1 or can file Tran 2. Next is that the Supreme Court has directed GSTN that now there should not be any technical glitches while they are opening the portal for these 2 months. Also, something new that has come up is that Supreme Court has directed that the revenue authorities can verify the claim in 90 days thereafter. Now, thereafter is an issue. I will address that issue. What does thereafter mean? And we will come to that, whether that thereafter should be effective from computed from November 1st, that is after the portal is open and the period for opening of portal 2 months expired, that from November 1st we will count 90 days, or if some taxpayer has say furnished Tran 1 on September 15, then the 90-day window will start from September 16. So that's not clear, and therefore this 90 days, what will happen is something that needs to be seen. And what the authorities will do, they will not only verify the claim, they will also pass order on merits. Now, what is the scope of this verification? We'll discuss that also. And they have to even afford opportunity of hearing to the taxpayer. So reasonable opportunity has to be given by the authorities before they pass any order. Once the order is passed, in terms of the order, the credit will be reflected in the electronic credit ledger of the taxpayer. And if required, GST Council may consider issuing appropriate guidelines to the field formation in respect of how they will scrutinize the claims of Tran 1, Tran 2, which are filed under as per the Supreme Court directions. So now, what is the way forward? First and foremost is that our recommendation is that those who are filing Tran 1, Tran 2, all such taxpayers must keep their documents ready, or they must collect necessary information, and they must have all the records in their possession before August 31, so that they are ready. There is no scope for any revision. There is no scope for further, filing of Tran 1 or Tran 2. So in one go, they have to do it. They must be clear, and also they must be prepared because there will be verification by the tax authorities. So all those documents must be handy and kept readily available. Second, what is the coverage of decision? Now let us see the scenarios. Okay, that will probably clarify, because most of the questions are emerging or coming from these aspects. So assume a taxpayer who could file Tran 1 during the relevant period, and whatever credits they wanted to avail, they could file the Tran 1, and full credits got reflected in their electronic credit ledger, got transferred. I think the matter is clear. For such taxpayers, there is no need to now file fresh Tran 1 or Tran 2. That chapter is closed. They are out of the purview. There is no need. Second issue that comes up is the cases where Tran 1 was filed, but credit was not fully transferred. It was either partly transferred or not transferred at all. Now that could happen. One could be because of technical glitches. In such cases, of course, now the window will be open and they can refile Tran 1 or they can revise their Tran 1. Second could be missed credits. Most of the what we have observed is that because initially in 2017 a limited window was kept open, the new regime had just kicked in. Taxpayers were not prepared. It was work in progress even for the GST network. There were a lot of changes that were happening, lot of glitches, and therefore certain credits got missed out by the taxpayers. Now all such missed out credits which are otherwise eligible in terms of section 140, those can now be taken through filing of tran 1. So there can be multiple events which occurred after enactment of GST, but important point is that those must be covered in terms of section 140. If they are covered by section 140, then such credits can still be transferred. If they are not covered by 140, they are outside the purview of 140 itself, then tran 1 cannot be filed. Then there are other options and we will discuss that. So third category is of cases where tran 1 is not filed at all. There were taxpayers who missed filing the tran 1, maybe because they were ignorant, maybe because of technical glitches they could not file tran 1, or there are cases where tran 1 was not filed for want of information or for whatever reason. But for any reason, if tran 1 has not been filed, those also can be filed now. And this is the biggest gain is to such people who did not file tran 1 at all, and now they have the window open for them. So we come to the open issues. So first open issue in this regard is the verification of claim, which is now a precondition for carrying forward of the transitional credit. So one, this was never prescribed under the GST law section 140 or 142, etc. Definitely rule 121 did permit the authorities that they can issue, just a minute, they can verify the claim and they can issue show cause notice under section 73 or 74 if they find any wrongly transitioned credit. Of course, that's another aspect, that transitional credit is not input tax credit under GST. What section 73 and 74 contemplate is only input tax credit wrongly availed. So transitional credit could not have fallen in that basket. Yet rule 121, and there is no substantive provision in the act, only rule 121 talked about such verification and issuing of demand notice. So what they have done now is that they have made it a precondition for verification of the tran 1 or tran 2 that are filed or revised, and for carrying forward of this transitional credit. Now the issue remains is that what is the scope of this verification? There is no clarity. Again, what experience we have got is that from experience, practically, the authorities go into the eligibility of credit itself. Now, eligibility of credit under the erstwhile laws cannot be looked into by the officers under GST. In GST, all they can see is whether in the returns that were filed on June 30th, was there a closing balance and that same amount is being transitioned, or is it more than the amount that was closing balance, or any other section 140 condition which is prescribed, whether that is adhered to or not. So whether it is capital goods, whether for different whatever other provisions are under section 140 where the transitional credit is allowed, if those are met, then there is no scope for further verification. But what practically we have seen is that authorities try to venture into the scope which relates to the eligibility of credit itself. So under the erstwhile law, whether credit was correctly availed or not, was it a blocked credit that was availed and reflected in the return? So in our view, that cannot be done. That scope of verification should be only as regards satisfaction vis-a-vis section 140 conditions. It cannot go beyond that. If authorities want to challenge anything about the eligibility, they must proceed under the erstwhile laws and not under GST law. So Supreme Court, while they have allowed verification, that verification cannot be to check the eligibility of the credit itself. Also, a lot of people have availed credit through 3B. Now that 3B could be availed in multiple situations. For instance, first is that there was the taxpayer approached the High Court. High Court allowed the writ petition and ordered portal to be reopened. That portal, if reopened, then ideally the taxpayer ought to have amended the Tran 1 or filed Tran 1, and accordingly the credit should have been taken. But in most cases, what we have seen is that in spite of High Court order, the GST portal was not opened and taxpayer was left in complete dark as to what he should do. So in certain cases, High Courts themselves directed to take credit, or High Courts permitted to take credit in 3B, absolutely no problem. But where High Court order is silent, but they allowed credit to be transitioned, in such cases, if portal is not open and taxpayer has availed 3B, in our view, that is valid, no problem, except that from revenue side, the issue of interest can trigger. And in such cases also, in our view, since it was an accrued right, since High Court had already allowed the petition, therefore, interest should not trigger. Also, in some taxpayer cases, there is no High Court ruling. They never filed Tran 1, they never approached any High Court, but straight away they have taken the credit in 3B. Now, in such situations also, what we feel is that they can file Tran 1 now. They should follow the procedure. And for the period where they are talking about the day when they took the credit through 3B, and for the period when the Tran 1 is being filed at this stage, whether interest liability will accrue or not accrue, since it was a vested right, the interest liability should not accrue based on equity principle. The authorities might demand it, but then one has to contest it, and then it will be a litigative position. But in our view, because all the situations, because the accrued right or the substantive right cannot be taken away, that credit was always available. Therefore, that credit ought to have been allowed to be utilized, and interest liability should not accrue. Another important aspect is what happens to the ongoing refund claims, because there are multiple issues or credits which are not falling within the scope of various options given under section 140. So what happens in those cases? Obviously, if a refund accrues, definitely under the erstwhile law, the refund claim needs to be filed, and that refund claim will be granted in cash. That section 142(3) and other provisions of section 142 clearly prescribe that such, except examining the unjust enrichment, no other provisions will apply, and the refund of such amounts will be granted in cash. Because now there is no scope for taking SENVAT credit or taking ITC under the VAT regime. There is no scope for possibility for transitioning. Therefore, because for transition, even though the window is open under section as per Supreme Court order, but the criteria of section 140 will not be met in those cases. Therefore, the only option with the taxpayer is to file refund claim under the erstwhile laws and get refund in cash. Now, there are refund claims filed for excise duty, service tax, VAT after enactment of GST, and this arises, as we just discussed, because Tran 1 was not filed by due date, and there were taxes that were there. There was, for instance, ocean freight service tax issue. Now it has been decided by Supreme Court in favor, but still the issue remains that taxpayers who had paid service tax on ocean freight after GST coming into place, then what happens to, because they were facing litigation, they have paid this service tax, they can definitely file refund claim. There is no limitation to this, and they can satisfy the authorities and claim refund in cash. Similarly, there are CVD, SAD that was paid. So countervailing duty and special additional duty. Now, what happens, say a case of EPCG license was there for importing capital goods. or there is an advance authorization which the taxpayer had taken, and the export obligation was to be met over a period of time, and after expiry of the Tran 1 period that was prescribed in the law, the taxpayer realizes that export obligation was not satisfied in full. Now they have paid the differential amount of CVD SAD. What happens to that? They are in the had the old regime been there, they would have availed Senvet credit of CVD SAD so paid. But since GST has triggered in, they can't avail Senvet credit, they can't transition that credit of CVD SAD they have paid now differential amount. So what the possibility, only possibility is filing refund claim, and that refund claim would still survive and they will get the refund in cash. There are favorable rulings also now on all these aspects. Next is the under the VAT regime, there were multiple statutory forms, C form, F form, H form, I form, different forms. And those experience tells us that those always are received much later, while the Tran 1 filing scope was over. So even the VAT, if you see any of the state GST law, most of them prescribe for refund of on the basis of forms which have been received after under the GST regime. So definitely that refund mechanism is open, and that credit pertaining to such statutory forms should be taken through the refund mechanism. Next is the carry forward of credit of cesses. Now it has again been a disputed area, because what is eligible duties and taxes, there are explanations 1, 2 and 3 in section 140, where explanation 3 clearly excludes inclusion of cesses from the purview of eligible duties and taxes. There's another debate that that explanation 3 has never been notified, etc., etc. So without going into those details, for the present purpose, it is important that these cesses, either they should be their credit should be transitioned, so that at least your because this matter is pending, whether transition of cesses would be allowed or not. This matter is pending before the Supreme Court at present. There are divergent views of the High Court, and now the matter is pending before Supreme Court. So question is, you must keep your claim alive, and therefore you must transition. If you have failed to transition earlier, you can transition these credit of cesses through Tran 1, and at best the authorities during verification will reject it. Whatever order comes, you can file an appeal, keep your claim alive till you get till the Supreme Court rules on the final outcome of this aspect. Other way is claiming refund under the erstwhile law of these cesses. That is another possibility, and there are rulings in favor on this aspect as well. Last point that we are discussing here is the possibility of extension. So what Supreme Court has said, they have given 2-month window for opening of the portal for filing of Tran 1 or revising Tran 1, Tran 2. So that 2-month window is from September 1 to 31st of October 2022. Question is whether this window can be extended. Second is, they have also given 90 days time to the tax authorities to verify the claims and pass order. So whether that 90 days period, that window can also be extended or not. So what our view is that, because these timelines are not flowing from GST law, from the GST Act, the authorities cannot extend time limit on their own, because section 168A or other provisions of the GST Act where they can extend time limit do not apply to timelines which are not prescribed under the GST Act. So the only possibility in such situation would be that if government would want to, or taxpayers would want any kind of extension, they have to approach Supreme Court and seek fresh extensions. And if Supreme Court allows extension, then only this extension will be possible. Otherwise, these extensions would not be possible. And we thank you all for participating in such large numbers and taking interest and hearing this webinar. Thank you.